So the next section is where I advocate that I stated claims that have merit for the First Amendment protections of freedom of thought. The explicit purpose of the CSA and both conventions is to prevent and combat the serious evil and immorality of drug abuse and its cognitive and emotional effects on the individual consumer. Thus, for thousands of drug evaluations over the past 60 years, the determination of how drugs will be scheduled, and thus whether mere possession thereof will be criminalized, is largely based on how a product might make us think or feel should we consume it. The United Nations, specifically the World Health Organization, and respondents have each created investigation protocols that they use for every drug evaluation to identify and presume potential cognitive and emotional states that could occur in individuals who consume the substance under evaluation. The evaluation procedures under the CSA and conventions share a common theme and define drug abuse accordingly. They both investigate, document, and define drug abuse as the thoughts, feelings, and desires an individual might have before, during, and after consuming a particular substance. Specifically, they investigate 1. Thoughts indicating individual motives for consuming a substance. 2. Thoughts, moods, and emotions that could occur upon consumption. And 3. Thoughts, feelings, and desires that might occur post-consumption. To investigate potential for abuse, the government and the World Health Organization go to extremely invasive and unlawful lengths to probe into our minds to predict our thoughts and feelings. They assign government employees to browse internet forums. They look for individual hobbies and personalities that indicate creativity. They conduct studies on animals and humans to extract and document potential cognitive and emotional processes. They investigate how much one thinks about using drugs and consider how people react to normal adverse life events. They look for indications of nonconformist thoughts and individual desires to gain introspection or expand consciousness. They further look for euphoric thoughts and feelings, as indicated by elevated mood, feeling abnormal or relaxed, and abnormal thinking. Any indication of euphoria, which is defined as extreme joy or happiness, is deemed by respondents as a key observation in determining potential for abuse. Their investigations into and findings of potential cognitive and emotional states encompass most of the drug evaluation process and serve as the primary basis for the determination of whether the harmless conduct of mere possession will be criminalized. Thus, the criminalization of mere private possession of a controlled substance is based almost entirely on the government's explicit desire to prevent certain internal thoughts and feelings it identifies as unfavorable or as a serious evil. The prohibition of government abridgment of freedom of thought is among the strictest of First Amendment protections. Unlike abridgment of speech or expression, where this court permits limited exceptions, it has firmly stated that there is no justification that permits the government to enter the private, sacred, and intimate realm of unexpressed human thought and emotion to either create or use as a premise for criminal legislation. The barrier prohibiting such intrusion is absolute and impenetrable. This court has interpreted this prohibition in two distinct ways, both of which were alleged. First, on multiple occasions, this court has found that the First Amendment strictly prohibits any consideration, investigation, or probing into personal thoughts to create criminal legislation or otherwise deny freedoms, privileges, or benefits. Government actions counter thereto, regardless of any offered justification, are unconstitutional. And then I quote some cases that were beautiful and relevant. The first one is Speiser v. Randall. And the United States Supreme Court says in that case, what one thinks or believes has full protection of the First Amendment. It is only his actions the government may examine and penalize. The next one, Schneider v. Smith. The First Amendment's ban against Congress abridging freedom of speech creates a preserve where the views of the individual are made inviolate. And then Baird v. State Bar of Arizona. Whatever justification may be offered, a state may not inquire about a man's views or associations solely for the purpose of withholding a right or benefit because of what he believes. Here I stated a plausible claim for relief that respondents' actions are constitutionally prohibited and thus violate the First Amendment. Specifically, I set forth numerous facts alleging the following. 1. The government and UN created an entire investigation protocol to identify and predict thoughts, moods, desires, and emotions that might arise in individuals surrounding the consumption of a particular substance. 2, they have used and continue to use this investigation protocol for every drug evaluation under both the CSA and conventions. 3, the findings produced pursuant to these unlawful investigations are used to determine whether the private harmless conduct of possession will be criminalized. 4, these investigation protocols and findings serve as the primary and foundational basis for the resulting scheduling decisions and criminalization of private possession. It is further worth noting that in my complaint, I quoted direct statements that I found in government documents used to determine when personal possession of substances will be criminalized, wherein the government explicitly references specific thoughts, feelings, and desires it identifies as unfavorable for us. Such statements should never be found in documents relied upon to create criminal legislation, and their mere existence in government records should suffice to raise a plausible claim under the First Amendment. Alternately, the Supreme Court has interpreted the First Amendment's protection of freedom of thought to mean the government cannot constitutionally premise legislation on the desirability of controlling a person's private thoughts. In Stanley v. Georgia, reviewed by the United States Supreme Court, the government criminalized the mere possession of material the government deemed obscene in the express interest of protecting the consumer's mind. The Supreme Court found that this was an assertion that the government has the right to control the moral content of a person's thoughts. The court further found that the First Amendment rights include the rights to beliefs, thoughts, emotions, and sensations, and to be let alone and satisfy one's intellectual and emotional needs in the privacy of his own home. The Supreme Court held that the First Amendment prohibits criminalizing the mere private possession of material the government finds offensive, and that the government's power does not extend to possession in the privacy of one's own home. Here I stated an additional plausible claim for relief under the First Amendment. I alleged respondents criminalized the private conduct of mere possession of certain products for the explicit purpose of preventing and combating certain cognitive and emotional states it deems undesirable. This allegation was adequately supported by numerous objective facts. The government's primary purpose for criminalizing mere private possession of substances scheduled under the CSA and conventions is clear, explicit, and stated within the laws themselves: to prevent and combat the serious evil and immorality of drug abuse and its cognitive and emotional effects on individuals. Moreover, before this legislation was renamed to the Controlled Substances Act, it was named the Comprehensive Drug Abuse Prevention and Control Act of 1970. As described herein, drug abuse, which the government seeks to prevent and control, refers to cognitive and emotional states of individuals. I further allege that this unlawful purpose is evidenced through the drug evaluation process, which is primarily focused on investigating and predicting the personal thoughts, moods, and emotional states that could arise in individuals should they consume the substance under evaluation. Without any analysis whatsoever or reference to relevant Supreme Court precedent or the pleading standards, within just 2 mere sentences, the Ninth Circuit dismissed my freedom of thought claims wholesale. This was disheartening and shocking, as I never foresaw the possibility that such significant claims, supported by numerous facts derived from decades of records and direct government statements discussing specific thoughts and emotions it seeks to prevent, could be dismissed without any court analysis or any indication they were read or considered. The Ninth Circuit created an insurmountable pleading barrier that no claimant could possibly overcome. The denial of being heard in any meaningful manner is a significant injustice to us all, especially when the courts, who are bound to uphold the Constitution, often serve as our only avenue to prosecute unlawful government action and vindicate our most basic human rights.